appeal in the matter of B and child.
Thank you.
Good morning, my lords.
Morning. Mr. Williams, let me unmask myself and take out my hearing aid. Before we start, I need to just be plain that this hearing is being live streamed. That means that the public can observe it on the live stream. Nothing that is said in the hearing is to be reported and published in any way that identifies the family members or this child or indeed any other children of the family. We'll try and conduct the hearing without using names. You shouldn't be too preoccupied about that. If a slip occurs, it occurs. It's protected by the ban on any publication, but we'll try and conduct it on that basis.
I'm grateful that my clients, my clients will be grateful for that information as well. They were both worried.
We weren't sure whether your respective clients were going to attend, and partly it's being live streamed so that they didn't have to, but I'm very glad that they've come.
Yes, I think they'd weighed that decision up themselves, coming from Nottingham and the difficulties of that. Yes. My lords, I appear, as you've already aware, on behalf of the appellant mother in this matter.
Yes.
My learned friend, Miss Limbry, appears on behalf of the respondent, the second appellant father.
Yes.
Miss Goer appears on behalf of the first respondent local authority,
yes.
And Miss Moore on behalf of the second respondent child. I have present with me my pupil, who hopefully can remain in the room.
No,
court.
Very welcome.
Permission. I've set out in the relatively brief document that I filed before the court, I think it was yesterday, the circumstances that have led to the mother being effectively represented pro bono. She hasn't had the chance of getting legal aid in this case.
I'm not sure I've seen that. I don't know if my lord and my lady have seen it.
No. Is that the references?
That's the references.
Yes, it's in the preamble to the references
it is
document.
Sorry, yes. Just to set out.
I haven't seen the references. I asked for the references document. But
they were provided to, I think all of your clerks were on the email chain.
We'll proceed on. I'll find it if I can.
The purpose for filing that in the preamble to that document was to explain, in part, the lack of skeleton argument from myself. The mother sought this appeal on her own behalf. There was no legal assistance save... thank you, my lady.
Right.
There was no legal assistance from her to be able to obtain that. The document that includes the grounds of appeal, which I'm going to rely upon, was the document I submitted to the recorder to seek to persuade him to give permission to appeal in writing, because my client had left the room at that stage and left the court to go and attend a therapy session. So that is going to be used as the grounds of appeal in this case, and I will seek to go through the submissions that I do with links to those grounds of appeal in the usual way.
If it helps, I'm sorry, I've sent to my lord the there's a paper copy of the references document.
Now, does that leave you without?
I'm okay to know.
Yes, no, I haven't seen that. So,
yes.
Mr. Williams, Miss Limbry has an adjournment
She does.
application. Nice. Is that one that you join in or not?
I'll let Miss Limbry make the application. My client is less forceful of the need for an adjournment for those documents to be obtained.
Right. So it certainly seems to me that we ought to hear Miss Limbry on the adjournment application first, and then see how we progress after that.
Good morning, my lords. I'm grateful to my learned friend for the introduction. I hope my lords have received the brief skeleton argument in support of the adjournment application.
Yes.
In essence, my lords, the position is this. I was not trial counsel for the mother, as the court will have seen. The grounds of appeal place sufficient, and I would say significant, in fact, weight on the oral evidence given at trial and the judge's failure to take that evidence into account in giving his judgment. The point, I suppose, is an obvious one. I wasn't there, so I don't know what that evidence was. I don't have a record of it. I've made efforts to try and obtain counsel's record of cross-examination, for example, but unfortunately trial counsel is sadly unwell, so hasn't been able to assist with that for the time being.
But it must have been obvious to counsel who drafted the original grounds of appeal, the skeleton, that they're relying upon differences between the oral evidence and the written evidence, and the failure of the judge to mention it, that a transcript was necessary.
My Lord, I accept that, but I think there is an important point that perhaps isn't clear to this court, which is known to me. The grounds of appeal, I understand, were drafted by Mr. Williams for use in the court below. He didn't play any part in the preparation of this appeal. So the parents essentially, as I understand it, took the grounds of appeal that had been drafted by Mr. Williams, took the skeleton argument drafted by Mr. Anderson, who was never instructed to act in this appeal, and lodged those documents. When
So what role did Mr. Anderson have?
I can probably assist easy with that. Mr. Anderson attended on the judgment day.
For the handing down?
No,
Or
so
was it
there were 4 days of evidence. We finished with the Guardian, and then the judge set aside, was put the case off for a week to hear judgment, to hear submissions on a later day. In between that time, his original counsel, who was Miss Gilead, became unwell quite seriously, and there was a concern that she wouldn't be able to attend that hearing. Magically, I say magically because I don't know how she did them, she produced some written submissions that were brief, but they were available. And therefore, Mr. Anderson attended that hearing just to supplement those submissions, and then he was there for the judgment.
Yes.
So that's the limited role that he
Well, I'm very sorry to learn that Miss Gilead.
I think she's getting better.
But Mr. Anderson is the author of the skeleton for your client. No, for your client. And that's signed, dated the 25th of January. So that's 2 months after the hearing.
That is right. I hope I don't miss.
So to say he wasn't instructed, that's what made me query how he was not instructed in the appeal if he drew the skeleton argument.
Yes, I can see the difficulty there. My understanding is that he produced the skeleton argument potentially on a pro bono basis, but that it wasn't his intention that he would then represent the client at the appeal. So he submitted the document. I accept that.
But in terms of he's not here to answer the inherent criticism in what I say, that the grounds that he's identified, I think I'm right, clearly rely in part on the lack of oral, the lack of information in the judgment about the oral evidence.
My Lord, you were right. He refers to it a number of times in his skeleton.
Yes. And it's paragraph 2b, if I've got the right skeleton. Yes. The judge ignored the evidence, which he should have taken into account, specifically the oral evidence. And so there in January, it must have been obvious to him, I would have thought, that he needed to have a reliable record of the oral evidence.
My Lord, potentially. I'm careful because I don't wish to malign Mr. Anderson. My understanding is that he may have been hopeful that the parents would secure legal aid for this appeal, in which case the bundle and supporting documents and any further applications would have been made by solicitors rather than by him acting in his limited capacity.
Yes. Well, all sorts of things might have happened, but nothing, in fact, happened. And so we're left with you coming in at very short notice, making the submission that the imminent appeal hearing date has prevented really any action being taken to remedy this deficit. And that's clearly right if you only, so far as you're concerned. But the observation that can fairly be made, I think, is that at least by the 25th of January, 6-7 weeks ago, counsel then acting for your client must have realised that there was a need for a transcript. And even if he was waiting for legal aid, other steps could have been taken. He could have contacted this court and indicated the matter. He could have approached the local authority or used the Guardian's legal aid certificate for a source of funding and flagging up the problem. But it doesn't seem that anything happened.
My Lord, I accept that, and that's why the moment I saw the grounds and was instructed, I immediately sought to remedy that deficit, because to me it's apparent, it's clear the court does need the transcript of evidence. The judgment alone is not sufficient. I don't know if Mr. Williams wishes to say anything further about Mr. Anderson's role, because I do have very limited knowledge,
No.
and I don't wish him to be unduly criticised if
But
in fact...
what clearly we have in our mind, I'm sure it's in everyone's mind, is that already 3 months have gone by since the judge's decision, and this child who's been the subject of care proceedings since birth is waiting for the process to come to a firm decision one way or the other. So to adjourn this appeal and get transcripts and then get you all to redraft skeleton arguments dealing with the transcripts and then list it again, we're looking at 3 or 4 weeks, aren't we, even if the best endeavours are used.
My lord, yes, I accept that, and I also accept it weighs against my application. But on the other hand, what I do say is that it's the nature of the application. It's serious, and the consequences are serious for the child, and it requires to be taken carefully.
We do have information in part as to what was said orally, because the judge does refer to some parts of the oral evidence, and Ms. Guha makes reference to the closing submissions of the local authority, and to a lesser extent is in the Guardian's closing submission. So it's possible to piece together some of what was said.
It is, but it's difficult for me to add colour to the black and white of what's in the documents. That is what's missing. And
but it's hard to, if it'll be said by the local authority and the Guardian that none of that, if I call that the known knowns in terms of the oral evidence, none of the known knowns are sufficient to lift this case above the level of risk that the judge had found. And it's hard to understand that there were other more striking elements of the oral evidence that somehow weren't mentioned by the judge or by the local authority or the Guardian in their closing submissions, which would change the risk assessment in a way that moves it to being arguably favourable to your clients.
my lord, my understanding is that significant concessions were made in cross-examination by the expert, by the social...
But how do you understand that?
Through conversations with Mother's Counsel.
Right.
And that potentially those do go beyond the scope of what the court currently has.
And Mr. Williams, you were counsel at the hearing.
I was.
You were, right.
The significant concession is made reference, the one that I will rely upon and I'll make reference to, and I do within the document that was sent yesterday, is an acceptance by the expert that is referred to in the local authority's closing submissions in relation to the psychological risk.
So there's a disparity between the position of Mother's Counsel and your position, because Mr. Williams is not actively seeking an adjournment and didn't, at an earlier stage when he was involved, seek any directions for the provision of transcripts. So he was in the room where it happened and heard what was said and didn't feel that this was necessary.
My lord, Mr. Williams does have the benefit, though, of having been at trial and heard the evidence.
But he can't give evidence to us about what was said. In order to make submissions,
no.
We would need to see the material detail of what was before the judge.
Yes, by some process of telepathy, which has not been interfered with by the screens that we still have, what was occurring to me was that your position professionally was very difficult because you arrived at this stage and you're bound to be concerned by what I had formulated as being the unknown unknowns, matters which you simply can't know about because you weren't at the trial and haven't seen a transcript. But the overall fact of the matter seems to be that the parents, although separately represented for reasons which are perfectly understandable, make, in a sense, the same case about the judgment and its alleged inadequacy. And that the submission that you're making in support of an application doesn't seem, in the light of the position taken by the mother, to go beyond the fact that you're in some difficulty knowing whether you can make particular points because of the absence of this primary information. Does that fairly characterise where we've got to?
It does, my lord, yes. I accept from the court's reception that that application is unlikely to succeed, and I don't.
Well, it might.
think any-
Certainly, a way forward is to proceed with the appeal and see how things progress and how much weight is being put upon what was said, and is not crystallised in the local authority closing submission, the guardian submission, or the judgment. If we keep your application under review, and there are other points in the case, it's right that I think we see where those go, and keep the matter under review as we move forward. So, speaking for myself, not dismiss your application, but not grant it.
I think it particularly goes to ground 3, doesn't it, which is over-reliance on written material. So that's where it particularly bites.
Yes, my lord, I'm grateful.
Yes. Yeah. So Mr. Williams, is there anything you want to say?
There's not, other than that I would share that view, and that's the point I was going to make in part with respect to the appeal. My ground 3 was an over-reliance upon the written material, and there is a very scant regard to the oral evidence. I've picked out, and I will make reference to the comment made by Mr. Marshall in relation to the level of risk depending on passage of time, that isn't recorded in the judgment, and you'll have seen in the transcript of the additional questions that I asked that was raised and not dealt with. But I would echo your Lord's view with respect to the adjournment. It will be an argument that I make that you should consider, at least when considering the prospects of the appeal at the conclusion of the submissions, whether you think it has any weight at that stage.
Good, thank you. No, I don't think we need to hear from either the local authority or the guardian. Is it just leaning across? Is it possible to find out where the banging is coming from and indicate that we can't have that going on during the hearing? Right. So, Mr. Williams, back to where we were.
As I say, I will seek to make submissions on the grounds that were drafted essentially for permission to appeal, that will then never be able to be further updated. I would hope the court doesn't require any further by way of opening. I think you've seen the documents and no doubt
we could
knowledge of the background.
Assume with confidence, because it's true, we've read all of the relevant papers.
The summary, which can become quite clear from the grounds of appeal that are drafted, is that I will be submitting that this judgment is flawed on the basis of a lack of analysis, a lack of balance, a lack of detail, and a fundamental inability to explain the decision reached when the judgment as a whole is considered. The application is for a remittal of this case to the Nottingham Court for a retrial. The court is well aware, and the authorities document contains certainly a number of decisions by your lords and will be relied upon, but the area of law is well known, well canvassed in the case law, in particular the high test that the judge was having to consider. And in my submission, this is what he failed to do, was that rigorous analysis of the case before him when considering his judgment. If there's any further matters by way of opening, I will go on to deal with the first ground of appeal that I raise.
Okay.
The first ground of appeal it relates broadly to the lack of analysis as to what the actual risk in this case was going to be, or was, moving forwards. This was a case...
No proper risk assessment. Sum up
Indeed.
what you're...
Quite properly, yes, my lord. This is a case of, I think one of the respondents' deals says it's a present and future risk. This is a child who was never in the care of the parents, and any risks were based on what was likely to happen to him moving forwards into the future. I sought within my opening note that was filed at the outset of the initial hearing, and that is in the C section of your supplemental bundle, starts at C211, and I'll make a number of references to this document to set out what arguments were before the court at the time when the case started. I appreciate with the lack of transcript, the court doesn't have the submissions that I made, but the court will no doubt take it as read that those points were pushed throughout the entirety of the hearing from the basis that I tried to set out within the opening.
So, although we have here opening note from you, closing note from Father's Counsel, really the opening note you carried through, and
I should have explained that. I've explained with respect to Miss Gilead and the reasons why she sent in the written submissions. There was never any order to file closing submissions in the case. Miss Gilead sent them, and I think the local authority and the Guardian just saw fit to follow suit. I took the view that I was going to be in front of the judge, and I would make my submissions to the judge, rather than to take the time over written submissions. Right. Maybe in hindsight, had we known we would be here, that may have been a different position. But the scope of the case put before the court with regard to risk analysis was sought to be set out in opening and was pushed through the hearing to all of the witnesses and then by way of closing. I raised in paragraph 3D of my opening note at C212 of the supplementary bundle, the risk and the criticism of the local authority of the welfare analysis being vague and limited to what the actual risks were. I made the point again within my opening note at C218 and paragraph D to seek to establish from the outset that neither of the professionals, being the social worker or the guardian, specifically set out what the risks would be. And in my submission, when looking at the judgment, that is a similar error that the judge himself fell into when he was composing his judgment. The focus of analysis, I raised the lack of analysis within my further queries to the judge at A44C of the document that you have, the bundle you have before you, which are the additional queries that I raised afterwards. The nature of these additional queries are that they, when you read back the transcripts, you may have thought you could put it slightly better, but A44C at the top of that page, A44C.
Which bundle are we in?
I prepared these bundles. They're in both. So the core bundle is replicated in the supplementary bundle.
Right.
So
which bundle are we in?
I'm just going to. Given it's all in the supplementary bundle, I was just going to refer to the supplementary.
Right. I haven't got part A of the supplemental.
Well, I can refer to it in the. It's the same page in both documents.
So in the core bundle, page
A44C.
I haven't got a page C.
Yes.
Page 44.
In the electronic version that I'm looking at, which may be the same.
So I can see now.
It would be page internal 48.
48, yeah.
Yes, thank you.
Yeah, okay.
At the top of that page, I make the point as a fourth matter that I may add, very poorly worded, there was no consideration within your judgment about the other arguments I made about the professional's analysis, particularly an indication of what the actual risk was that these parents would pose, their evidence and any analysis that you undertake. And I go on to make other comments. So in my submission, that was me seeking to highlight to the judge that he hadn't undertaken in my submission an analysis of what the actual future risks posed were.
I would say, key stage in any proceedings of this nature is to identify the risk. And one of the ways in which the court does that is in relation to findings about the threshold criteria. Now, reading the judgment, it doesn't seem to me that there was any finding in detail as to why and on what basis the threshold was crossed. The judge reads out a summary of what the local authority were asserting was included in the threshold criteria, and he notes that it's conceded. And I think in either one or other of the skeleton arguments for the parents, it said the threshold was conceded, and you're not suggesting it wasn't met, and I'm sure that's right. But there's, am I right? Nowhere was it crystallised into a finding that this is why this child got the findings in the past.
I think that is the point.
Why this child is at risk.
And that's my understanding of the threshold document isn't in there, and I noted that when I was looking through the documents again last night. If the court would want it, I'm sure I can obtain it. There was an agreed final threshold that was agreed. I'm almost certain. Yes, there was.
And the judge doesn't.
Confused. Well, yes, well, that may go back in part to
Electronically, we have about 4 bundles. We have the core bundle,
Yes.
the supplemental bundle, which, as you say, overlaps the core bundle in relation to the appeal documents. We also have an authorities bundle, which you've already referred to. But there is, lying behind this, somebody has filed the trial bundle, which I'm just looking at the index to the trial bundle, which is yet another.
Yes, I haven't got that. I haven't got the authorities bundle. It's not anyone in fault, but I don't know how that's happened.
It may be for no more than noting purposes, but that in the trial bundle, so using what the judge had in front of him, A54 to A55 is what's described as the final threshold. Right. It is a 2-page document, yes, running to 7 paragraphs, which is readily, as it were, accessible.
And is that the document that the judge may have been summarising in his judgment?
My memory of the case, when I look back at it yesterday, was that there was an agreed version. I represented the mother only at the final hearing, so my understanding was there was an agreed document beforehand. I would like to have a chance when I'm sat down to consider that document, but I'm fairly clear that it is a document that your Lord refers to.
That is paragraph 7. The judge says, in its final threshold, the local authority referred to findings. But it's not clear to me that he found.
There were no additional findings being sought by the local authority in addition to the threshold. One of the matters that was raised in part was, are there any additional findings being sought about other incidents or other events that aren't covered in that document? And there were not. I don't think that can be disputed. So the document that was being put across in advance of the hearing, which my Lord has referred to, my understanding was the final version, but I will double check that.
Well, I don't know whether it's because it's a short document and it's readily capable of being summarised. I don't know whether it would be helpful if I simply summarised what the points are. It's a 2-page document.
Yes. I can read it, in fact. Yeah, that is it. Okay, you want to go? No?
Does anyone else have access to the original bundle? I don't want to have documents that no one else has access to. Well, I can share them with all of you. I'll put it on our share file system.
Right, carry on. There's just a bit more so those are 7 paragraphs making assertions about the parents and their ability to care for the child. Your point is that there was no risk assessment, and indeed this child isn't mentioned, I don't think, in that threshold document. It's a list of...
No, it's difficult to see, but the child is mentioned in paragraphs 6 and 7, which is to do with parental honesty, working to safeguard the child, and home conditions.
But your point about risk assessment is a different point.
It is a different point based on what this
judge
you're
saying,
undertaking.
Putting it in lay terms, you're saying, okay, that can be said about the parents, but nobody's looked to see what the implications of those findings are in terms of the overall risk to this child.
And the focus of the questions to the professional experts, including the psychologists, were to seek to identify how those static factors of historic concern passed forward to this child and what was suffered to him.
Whilst we're pausing there, Ms. Limbury, I see your client has had to leave the room for a short time.
Yes.
Are you content to continue?
I am, yes. Apologies. He just simply wished to pop out to go to the toilet.
No, fine. That's entirely understandable. But as long as you're content to carry on.
Yeah. Whilst we're dealing with the threshold, when I've now been able to download the original bundle, I'll give access to the other parties to it. I think it's a clean version I've got. My client had filed a response to the final threshold, and a large number of those were accepted. And a number of those are actually matters that the father could respond to. My Lord, who's got the document, it is A64 of that original bundle, but I can make both documents available to the court and to the other party. This was certainly not a case, though, where the court was being actively asked and the judge doesn't make any findings in relation to further matters and was dealing principally with the threshold grounds.
So I derailed you from your course, which was to make the submission that neither the social worker nor the guardian had actually set out what the risks would be to this child. So if you want to carry on where you would
and that was the focus of the questions with them beforehand. And the critique that's made in the opening note, and again, hopefully the court will accept was made throughout, was there was a simplistic analysis based on there are two negative assessments, to use their term, therefore the consequence must be this child needs to be placed for an adoptive placement. Inevitably, there was challenge on that simplistic analysis had throughout to try and understand what the specific risk posed to this child would be in these parents' care, and to try and get an analysis that could then be followed through. My critique of the judges is, despite that attempt, both in opening, attempt to get it in closing again, and to the witnesses, is there's no apparent exercise by him to do that rigorous analysis of what is the risk that is posed to this child, and what is the quantification of it. And in fairness, very grateful to Ms. Gilead's closing submissions, but within that document, she herself tries to make that point to the recorder, and I'll find the page reference. It's in the supplementary bundle, and it's at C227. And it's in the likelihood of harm section on that page. For those using the electronic bundle, I think it's page 416.
It is.
Right.
She tries to set out to the judge the way that this case needs to be approached on risk, based on the nature of the harm at paragraph 30, and then moving on to try and suggest to the judge that you need to look at both the risk itself and then the likelihood of harm from these parents.
In terms of the nature of the harm, in view of the findings that Judge Lee had made, the judge focuses on, and the hearing seems to have been focusing on, who was directly physically responsible for the injury to the older child, and that's understandable. But the other half of Judge Lee's findings were that whoever was of the three was not involved would have known what was going on and failed to protect the child. So part of considering the potential for harm to this baby is Ms. Gilead's submission that there's no basis to conclude that this child would be at risk of physical harm from either of these two parents. That's the submission. That's only part of the story. Are they able to protect the child from someone else?
Indeed, and there's no analysis of that alternative argument within the judge's judgment either. These are two parents.
The judge doesn't refer to failure to protect at all, I don't think.
No. And that is one of the critical failings of it. There was a lot of focus, as the court has seen in part without the transcript, to whodunit scenario, frankly. Yeah. Was it this third-party individual, or was it one of the parents? Focuses a lot in the local authority and guardian submissions in relation to that principal consideration, whether the parents accept it matters. But there was a lack of any analysis as to if it was the third party, what is their ability to protect? And coming to a latter ground now, but there was a focus had to try and put the positives of these parents to the witnesses. No reference within the judgment to those positives. But there was a focused attempt to put that these parents, save for that individual with that injury back in 2013, there's no evidence of other associations with those who are of risky individuals. The critique made of them in many ways in the local authority documents are that they keep themselves more to the point. The only critique the judge goes on to make is that the father purchased cannabis in March 2021 on a single occasion for some other individuals. So there is no There's no analysis of what the other risks and failure to protect would be from other individuals. And then secondly, there's a question mark as to what that actual risk would be in any event when based on the factual information that was before the court. There's repeated evidence, going back to the points I was on, there's repeated reference to those findings made by His Honour Judge Lee in 2013 regarding the injury. The finding, very difficult to distill from the document produced by the judgment produced by the recorder, but the finding was that a child aged 7 suffered a single blow to her arm, leaving her forearms being bruised. Findings made in June 2013. The findings were 8 years old at the point of the substantive hearing. No repeated incidents. I accept there were no children in their care during that time, but no other instance of concerns. It was a clear and obvious point to make, not considered by the judge, as to whether those risk factors had mitigated to some extent over the period of time that had passed. There was an issue of risk management as to whether that made it unsustainable, or risk analysis, whether it made it unsustainable for this child to return to the parents' care now, a different child, all of those years later. In my submission, there was an oversimplified view, both from the judge, but also partly led by the witnesses that were before him, about the lack of acceptance meant the risk was unavoidable. There was repeated attempts during the hearing to challenge that narrative, and Ms Gilead's submissions make that point as well. And in the judge's judgment at paragraph 19, and I'll bring up the page, I think it's an A35.
Page 36.
Page 30.
No,
internal
page
page
35.
A35. Paragraph 19. There was a number of comments made, including this one, about whether the parents accepted the findings or not. And there was a lot of focus put onto sort of eureka moment of an acceptance of findings by all of the individuals, but particularly by the judge, when that had been attempted to try and to argue against him. There was an attempt, as I've said, within Ms Gilead's document to try and avoid the exercise of don't accept findings, can't care for other child. But that, in my submission, is what the judge appears to have gone on to do. The judge was taken, and I think it's important for this court to consider the finding of Judge Lee, and in particular to what are differences between the parents' positions, even if they hadn't changed dramatically, in the judge's view, there had been quite significant changes. In the supplementary bundle at D16, the court's got His Honour Judge Lee's relatively short judgment, I must say, in respect of injuries in November 2016. And at paragraph 22, he describes the situation that was before him on that occasion and the behaviours and the attitude of the parents that were before him on that at that point. Wait for your lawyers to get that.
No,
Paragraph 22, he says, as readily as this year, the mother was seeking to oppose the adoption order in Chloe's case. The circumstances that the findings I made 3 years ago were wrong. So that's what the mother was saying in 2016. He goes on to say a few lines down, the mother indicated only in the blandest of terms that her parenting fell below a reasonable standard without any detail given or analysis as to why that had happened.
This is at page 460 of the electronic bundle.
Yes, 400.
The internal numbering.
Yes.
The electronic number.
400, yeah. I'm
460, you're reading from paragraph 22.
I am, yes, thank you.
Thank you.
My lord. And then over the page at paragraph 24, there are further comments in relation to, I believe the local authorities' failure to help Helen and I led to this situation. There is then a comment further next line down about feeling bullied and threatened by the present situation. Paragraph 25, there's reference to the parents believing that the experts were lying.
So what, are you making these points to say that the parents' position had evolved to something subtler by the time of the present
It was certainly
hearing?
different to what it was in front of Judge Lee at the time. So for any suggestion, because they're dramatic, there's other references further down,
Yes.
the court can read them. The parents had notably changed their position, and there is no reflection of that anywhere within the judgment that these things were different, and therefore the analysis of risk, not just from the passage of time, but from the comments being made by the parents, particularly about the injuries, but also in respect of what they were saying about how professionals were acting, was different. Now again, I accept one of the difficulties for the lack of transcript is you don't have much by way of what the parents were saying to the judge in that.
That's what I was going to do. We've got the reference to what the parents were saying to Judge Lee, but where do we have the material that shows that they'd changed?
Neither, well, again, this is a matter for what the local authority and the Guardian relied upon, because that's the limit of the documentation that I can utilise, is that there's no references to those sorts of comments still being made within these proceedings. And they're certainly not in the documentary evidence that people point towards.
But it could be said, and clearly I've only come to this case this week, and so my impression may be not justified, but it could be said that at any one time the parents have said different things and they chop and change, and you take a photograph of it on one day and it may be different the next day. And so the fact that there's been change does not of itself take the matter much further.
I can accept that point, Your Honour. Accept that, and I don't disagree that the other parties would inevitably say there has been change, and I wouldn't suggest for a second that there weren't differences in their account on different occasions. But it's the nature of the change was...
I mean, in a significant violent event happened to the older child, the three people, these two parents and the other man, were the primary carers. Those three people must know who did it. And there's been a havering around that issue for going on for a decade. And the fact that the havering takes the parents to say one thing one week, another thing another week, none of them, those two, certainly that we haven't heard from the man, neither of them have grasped the nettle and been clear and frank about something that they must have known from day one.
And that was the recorder's view, and I'm not going to necessarily...
But it's very difficult to say that that's an incorrect view. And it's a view that doesn't need to take account of what precisely the change in what they say is this week or last week or the week before.
Moving on to the issues of the matters that were able to be identified by the judge by way of risks appear to fall down to ones...
Would you mind if I just asked you a further question about this particular point? Because you were focusing, I understand why, on the question of the past injury and the degree of acceptance. And your submission had got to the point of saying that they were all out, in a state of all-out rejection, even in 2016, which Judge Lee's second judgment had. Again, understand that. But if we could just look at these paragraphs in the judgment, paragraphs 18 to 20 and 30 to 31.
Are we looking at the
in the current judgment of the recorder?
Sorry, 18 to 20.
18 to 20 and 30 to 31. Here we have passages, which obviously we've read more than once, in which the recorder is setting out evidence both from then and from now, which leads him to his conclusions at paragraph 30 and 31. So he's dealt quite in quite a detailed fashion with what had been said, what one would expect parents in this situation to do, considering the catastrophic consequences of what had happened in the past. But when we get to paragraphs 30 and 31, paragraph 30 starts with consideration of sustained change and moves swiftly to mindset about the previous proceedings. And then just jumping over what is said at the end of paragraph 31, a clear conclusion. Now, just following upon what my Lord has said, I'm not sure how you would seek to sustain a challenge to the recorder's position, which is that although they may have dressed it up a bit at this distance in time, really they're stuck where they were in relation to that. I understand that you can go on and say that's not the only feature of risk, but it's a pretty big one. And are you able to sustain an argument that this was not open to the recorder, having listened to the oral evidence of the clients?
The point I was trying to make in a succinct way was that whilst there may not have been a whole-scale acceptance of matters, which my Lord correctly points out, is there had been a progression of some sort from the behaviour and the attitude.
I understand that was your submission, but the judge's conclusion was against you on that. He said there is no acceptance or understanding. So it would seem not like, as it were, a submission ignored or misunderstood, but a submission rejected. So I don't want to, to press the point further, but just to see how this fits in with the judgment.
It in part led to the point of there are other risks that need to be identified. And if that is the risk, there is a simplistic analysis of that being the focus, which appeared to be the focus of the other documentation that was led.
So we can now move on to other risks.
I won't move on. I won't push that point any further with respect to matters. I've already sought to deal with how Miss Gilead indicated within the written document at C226 to 227 about the identification of that risk, and then the likelihood of it occurring, and then the consideration of mitigating or reducing factors. That is not what is seen in my submission within this judgment. There is no proper identification, although there is comment in relation to what that risk is. There is no identification in my submission as to what that risk actually is. So a summary of, you can glean in part from the judgment that there was a concern about these previous injuries, lack of clarity as to what other matters there were. But then in my submission, there is no attempt to quantify that risk or to then consider what the mitigating factors potentially against it could be. Indeed, there was no attempt, as I think I've made already in point, that there was to set out what those risks perceptively would be. There's a comment in my submission in relation to the judgment in generalities, without specifics about what the risk to this child would be if he returned home to the parents' care. There is no attempt to really consider matters other than the comment that's made in relation to honesty. I'll just draw that up. In paragraph 38 of the judgment, A40 of both bundles, talks of, dismisses any suggestion of limiting factor or any suggestion of mitigating factors with his last couple of sentences in that paragraph 38. Any safeguarding plan would require openness and honesty for it to work. Parents have demonstrated they cannot do that, and father's aggressive responses to matters of concern. No other attempt to seek to consider how risks could be managed with respect to...
And there was the residential assessment report, and that unfortunately identified a deficit in the parents' ability to care really across the board. And as the judge found at paragraph 33, or he certainly agreed with the social worker, it seems, that the social worker pointed out that 24/7 support available in the residential unit wasn't sufficient. And so the risk was that on a global basis, in virtually all aspects of parenting, apart from feeding, I think it was, it would be likely, left to their own devices, that the parents would fail to provide adequate and safe parenting.
And on that point comes to probably the third ground I was going to make in relation to the lack of evidence referring back to the witnesses. You will see from the opening note that I filed that it is, when the report is considered in a deal of detail, it is far more nuanced than that in relation to their concerns about matters, and particularly the incident of concern that occurred partway through that residential assessment of the father's dishonesty in relation to the third party being in communication with him. There is a notable change in the concerns of the unit following that event. And when I was going to take the court to...
Well, you'll come to that. That's a different submission to say that there's no identification of risk, because certainly a reading of the judgment is that the judge was identifying the risk, which was, sadly, that the parents across the board were unable to demonstrate that they could provide safe parenting.
The critique that's made about paragraph 38 is, though, that there's this view that these parents were dishonest and continue to be dishonest. There had been no finding of dishonesty recently. The last incident of any concern of honesty in relation to these parents was back either in the November of 2021 when they were at the residential unit, or there was a second occasion of dishonesty in the January when they'd left the residential unit and they were dishonest about whether they were sleeping in a rental car or not. But there were no other incidents of dishonesty by these parents at the local authority.
Was that the same as the car?
That's the car, yes. They were homeless, they were renting a car, they told the social workers they were sleeping rough.
And that is dealt with by the judge at paragraph 28.
Except that he deals with the incident of that. But those are the only incidents of honesty that the local authority were reliant upon.
But the trouble about honesty is that it's a bit of a balloon, isn't it? I mean, if you can't trust somebody, if knowing that this is an important matter, people just lie to you, then where does it end? Of course, it's not the only factor, but it's a crucially important factor in a case of this sort, isn't it?
I don't disagree with that. I'm just setting out the comment in relation to a continuing dishonesty when there hadn't been any examples of dishonesty that was continuing. I'll take your honest.
When you say specific examples of dishonesty, one's also got to look at the totality of the evidence, doesn't one? And one looks at the inconsistent accounts given as to the injuries that we've been discussing. That was a factor of which the judge could and did take account, was it not? It was also a point raised by Mr. Marshall, very clearly.
It was, with respect
Yes.
to Mr. Marshall, yes.
You were overlapping the question of quantification of risk and also identification of mitigating factors. We were just looking at paragraph 33
Yes.
a moment ago, which begins with the cross-examination, no doubt from you, about support, and that's something which sometimes one doesn't see in a judgment. It doesn't get thought about. But in this case, you did challenge that, and the social worker wasn't having it. I don't understand that you're suggesting that the judge has misunderstood the nature of the evidence about that. It was simply that the social worker gave that answer.
The social worker certainly gave answers that he didn't think there was a proportional response. And I don't disagree with that. But there was inevitably further challenge as to what really is the risk that you're protecting against.
And but when we're talking about them, because mitigating factors are very important in considering what the scale of risk is. If you can provide support that removes the risk, that of course is relevant. But what was it that's being missed in relation to mitigating factors?
The mitigating factors that were being relied upon was whether realistically an injury that occurred 7 years ago, plus ongoing concerns in relation to
But that's a different point. I mean, I do understand the points you make about that, but mitigating factors is usually, well, the house isn't going to get into a state because we're going to send in a family support worker 3 times a week. That's a reasonable thing to do, but I don't understand at the moment what the lack of identification of mitigating factors amounts to in reality in these circumstances. Either you could or you couldn't, said the social worker.
Just drawing up my notes of what submissions I made in the court below. Inevitably focus on what supportive measures could be put in place. There's no consideration of visits set out by this judge. There is no consideration of other matters inevitably raised in relation to written agreements, regular drug testing on behalf of the father. There's just a wide-spread social worker said this. I haven't analysed that myself, and I just say that can't be done. In my submission, there was no attempt to focus on that issue as to the matters that could have been done. If he comes to the view they weren't sufficient, potentially so be it, but there wasn't in my submission any particular consideration of those mitigating factors that were suggested to him. With respect, finally, in relation to this first ground, I've made the point of dishonesty, and you've all made comments with respect of the nature of dishonesty and whether it can be trusted. There were no allegations of my client's honesty, save for the point my lady makes in respect of the findings and whether they were being honest in relation to what had happened with those. There were no other instances of dishonesty towards professionals, save for events of 2013. And so when it is the parents are lumped together with respect of an honest individual, there may have been issues with respect of the father in relation to the third party, but save for the car, there were no instances involving my client. And in my submission, that is a simplicity that the judge had around honesty. Can't trust either of them, therefore cannot have orders being made. So broadly, with respect to the first ground, I submit that the case fundamentally was about a management of future risk, and the judge properly failed to consider what that risk was, and having had that raised with him, having it raised with all the professionals in front of him, their attempt to identify risk, having had it identified to him at the end of his judgment that he didn't cover the matter, he still didn't comment upon the point. And in my submission, he erred in failing to do so and provide a proper analysis on those points. I'll move on, unless the court's got any further questions in respect of that first one, to the second ground, which is more in relation to the substance of the analysis taken upon by the judge. And in my submission in this case, there is a lack of a balancing exercise undertaken by the judge when weighing up all of the available options to him. I doubt that the local authority or the guardian in this case will argue, I didn't below, that the parents were a realistic option in this case. There was no attempt to suggest in any of the written documents filed or in any submissions that the court shouldn't be considering of them as one of the realistic options.
Shouldn't.
Shouldn't. They should have been. They were one of the realistic options. And in reality, the parents were not pushing, as often don't in these cases of long-term foster care, given the inevitable arguments that will be made against it. The court therefore had two realistic options before it, and the weight of the case law, which I was thinking of taking the court to, but I may not, is that there needs to be that analysis of those two options, pros and cons of those.
And the judge correctly, you would say, identifies those as the two, as the placement with the parents as being one of the realistic options.
I'm not sure, my lord, that he does identify that
I think 41.
I thought I'd got it somewhere.
Middle of 41.
Yeah, middle of 41. The realistic options and choices, therefore, in this case are stark. Return to parents' care, long-term foster care, he puts it in, foster care with a plan for adoption.
He outlines the options, I accept, and I've got that in my notes, paragraph A41, paragraph 41, and then the analysis appears to be over the following paragraph. So that's where we're looking for the holistic analysis in respect of the placement options.
No doubt you'll come to, what you can say is that the judge then went on to look at the parents and then ruled them out as a realistic option before looking at adoption.
That is the point.
That's you're going to come on to that. The fact that they mentioned in 41 as a realistic option doesn't mean that they make it as far as the balancing exercise.
Indeed.
Yeah.
That's the point simply I make, is that there doesn't seem to be, and the authorities bundle, will, unsurprisingly to my lord who hasn't had that document, contains the case of ReBS and the dicta within there about the need for adequately reasoned judgment. And in my submission, that is what we do not have in this case. With respect of that judgment and the identifications therein, there doesn't seem to be an adequately reasoned judgment, I would say, with respect of why that was reached. There is then this is paragraph 41 of ReBS, internal page 11 of the authorities bundle, so the court needs to be reminded of it. It's then the comment made, Lady Justice Black's comment in P, the judge needs to carry out a proper balancing exercise, whether it's necessary to make a care order, and a proportionality analysis. In my submission, when we consider the analysis undertaken, the word proportionality is used almost as a sort of throwaway comment in respect of proportionality. There's very little, if any, proper consideration of what proportionality is that's being considered. There is no, moving on to the other parts of that judgment, the ReBS judgment, the judge is said at paragraph 42 to grapple with the factors at play in the particular case, give proper focused attention to the specifics. Again, Lady Justice Black's words. In my submission, there is a lack of any specific proper attention to the specifics within these parts of the analysis. I'll return in my last ground to the respect of the linear analysis, which the court's already referred to, but there does seem to be quite clearly a linear analysis undertaken here. Parents are not an option. I won't even weigh up the pros and cons with respect to the parents. I'll just go on to consider, for some unknown reason, the balance between long-term foster care and the placement order, which was not being argued as the realistic options that the court needed to weigh up between the two. Paragraph 45 of that, 44 of the ReBS judgment emphasises the words holistic, global holistic evaluation, point being crucial, all the options, multifaceted evaluation of the child's welfare, all the pros and cons of each option. And in my submission, that simply doesn't occur in this judgment. There are no balancing of any pros, partly one of my latest submissions as well. There is no consideration of any positives from these parents at any point within the judgment, save for one that I think is identified by the Guardian's representative, where he refers to the expert's evidence who was able to see that the father stopped using cannabis and they were engaging with therapy. Those are the only identification of any positives of these parents. One of the main focuses of drafting an opening note to the court was that was the tenor of the social work evidence in this case, and the Guardian's evidence is a failure to identify proper positives. And when the court considers, again, my opening note to the court, particularly, this is at C212 of the supplementary bundle, the internal page 401, I produced a long list at my paragraph 6 of all of the positives, what from A through to I, of these positives in relation to the parents. No concern about contact sessions, attendance, no concern about their warmth and stimulation of these parents, no concerns in respect of how he was in the residential unit, how he was thriving in the residential unit, no concerns about their commitment, no concerns about housing more recently. The list goes on, and I won't repeat it to the court, but that they were there. And there's no comment about the positive pros and cons because the judge simply didn't undertake that analysis. And in my submission, how a global holistic analysis, in my understanding, is meant to work, is to do that analysis of these are the positives that could be had for this child in the parent's care, these are the downsides, and this is why I come to that decision. If the court makes no reference at all to those positives, how can there have been a proper analysis of matters?
What do you make of paragraph 34?
They love their son and can generally meet his needs. They have a bond with him and can work together. I think if that is the limit of the positives that the judge was able to articulate, having heard all of the witnesses be challenged upon the positives, and this is accepted within the local authority's closing document, that I put all these positive points to all the various witnesses as a factual basis. In my submission, that is a relatively limited exploration of any risk, and again, it appears to go towards the limit of what can often be said by a judge in some cases, that the parents love their child. Basic analysis of some matters. But in my submission, generally meet his basic needs. It goes far beyond that in my submission in relation to the positives and the pros and cons that should be carried out.
In a way, you've put your list there from A to I in paragraph 6 of your opening. That's what the case was about. If the judge had chanced upon the parents as Judge Lee did back in 2013 and 2016, he may not be criticised for judging them as Judge Lee did. Your case was that was then, this is now. They've changed, and so for the judge to judge them in the back end of 2021, you would submit he had to look at that list and then balance it up to see whether it was whether it was there were sufficient changes, and B, whether this altered the balance of risk.
And my point is, I imagine the point we made, well, he did try and balance matters up. In my submission, there's no evidence, save for the paragraph that my Lord's referred to, of a fleeting comment in respect to the positives. There's no attempt to consider those
I
points.
understand the structural point that you're making, but if we look perhaps at paragraph 23, this is
That's
in
the
the
other
course
comment
of,
I referred to.
this is in the course of the judge's analysis of the expert's evidence, which was positive notes in regard to father's cannabis use and his response to that, also therapy, also no domestic violence. And I quite understand from a forensic point of view when one presses these points and doesn't see them coming up, as it were, at the final cashing up of everything. But it's difficult, isn't it, to say that the judge didn't have these points in mind, however he expressed himself in his ultimate reasoning.
Well, it doesn't appear in the ultimate reason.
Well, that's what I was going to go on. So the purpose of an ultimate reasoning is to draw all that together. It's not to say, well, I'll look back at paragraph 23.
When you would expect, if they were in the forefront of the judge's mind, despite the fact he mentioned them back in paragraph 23, for those then to pop back up in paragraph 34.
Particularly because paragraph 23, in my understanding of reading of the judgment, is him just going through the evidence that was available to him and just noting some positives, rather than drawing the matters of balance together.
And I think also, my reading in paragraph 23 was that was either entirely or largely an account of what the expert had said in his oral evidence.
Yes.
That these were the things that had happened since the assessment, because we're there dealing with March 2021 and September 2021, so after the written report had been prepared. And so that's an example of, you say, the judge not taking account, when he came to his final analysis, of material that was outside the written reports that he'd got.
There's no reference back to that. I think that's the limit of what I can say. Is the purpose of a structure in these judgments is to give that structure, and so that someone like me in front of a bench like you can't say, well, he didn't consider these things, because save for reference back, there is no proper analysis of matters. And in my submission, that is where the holistic analysis simply didn't take place in this judge's reasoning. Whether anyone can argue it happened in his mind is obviously beyond all of us. And in my submission, it doesn't appear in the written documentation. I was going to go on going back to the REBS list at paragraph 45, and my Lord's comment with respect of is set out within there about the acknowledgement about, I won't read it out, such description fully, such descriptions are appropriate and correct. There's a danger these phrases inadvertently become little more than formulaic window dressing. That is in relation to comments in relation to nothing else will do. The judge does make reference to nothing else will do in the judgment. I don't disagree with that. But in my submission, when the court finds it within the analysis, it is, I do find it in the analysis, it is much more of it's at the bottom of A42, the end of paragraph 46. Is if it said that he properly considered the weight of what was being asked of him, to make the comment, the oft-used phrase that I must be satisfied as nothing else will do sums up the fact that adoption is the most draconian order a court can make, is a fairly glib comment, I would submit, in relation to the wealth of, or the bulk of the case law that emphasises the importance of focus, attention on that point. And in my submission, what the recorder does in this case is exactly what my Lord warns against in that previous case that is quoted in REBS at paragraph 45. My submission is he gave scant attention to any sort of balancing exercise and then sought to give no more in my submission than lip service to the proportionality argument that would be made about the orders that he was proposing. There was no, moving on to another point with respect to the properness of the analysis, there is no consideration of proportionality in my submission in this judgment. There is one reference, I accept, to the word proportionality. But there is no balancing of the long-term risk against the long-term risks of both options. There's no attempt to consider whether the injuries being now 8 years ago justify the removal of this child at this moment in time. And in my submission, just to say the realistic and most just and proportionate option, which is the only reference to proportionality.
Well, which paragraph is that?
I think it's in 46, but I can't now find it.
Paragraph 45, there's a reference to proportionality in the context of adjournment.
Yes.
A couple of references there.
And he does at 47 consider the effect on the child throughout his life on ceasing to be a member of his original family, the severing of family relationships.
Yes.
And at 48, again considering the child.
49 is
Just and proportionate
is
is
the
49,
parent.
isn't it?
Yes. Again, I think my point with respect to the proportionality analysis is that is the reference to proportionality. In my submission, there doesn't seem
And
to be
that falls in, you would politely say, into the window dressing
indeed.
category.
He's used it. Let's have the word
It's after.
proportionality in
It's
there.
after he's made the decision. It's not.
I think my point would be, if you were doing a proper proportionality exercise, you would have balanced the options I've already dealt
Yes, it
with.
would be.
Then you would say,
It would be within the structure of the exercise rather than an add-on after he's concluded.
so you would say, I need to consider the proportionality of the decision I'm making. That is the emphasis of all of the case law in Article 8, and this is the way that I think this is a proportionate decision, rather than saying afterwards, I think I don't. And so my submission that isn't evident from the documentation that we have before us. So just bringing all this ground into some general attempt at a conclusion, the analysis itself in my submission is limited and gives very little consideration to arguments made. The same point can be in part made with respect to the adjournment arguments.
But just before you get on to that, in certainly my reading, paragraph 46, this is where the judge moves on to look at adoption.
Yes.
Local authority's plan is for adoption. Of course, I have to consider the welfare checklist from 2002 Act, which is similar to 1989 Act, with the difference that paramount consideration must be a child's welfare throughout his life. So that's the difference between the welfare principle. The difference between the checklists is important, and the checklists, particularly at C and F in the Adoption Act, require the judge to undertake the balance of what's the child going to gain from adoption and lose from adoption. What are the relationships the child has with the natural family? What are the value of those relationships? How can those individuals provide for the child or not? And it was striking to me that the judge didn't refer to the checklist at all. One doesn't, sitting in this court, require judges slavishly to go through the checklist, but I'm sure with some confidence that every judge who's trained about adoption is told that they must include in their judgments reference to C and F, because that's the engine room of the adoption balance. Now, you're not going to win the appeal simply because he doesn't mention them.
No.
But it's not just the fact they're absent any reference in the judgment. There's no indication that the judge did it.
No, well, and that's
The
it's
judge
more of window
conducted
dressing.
that balancing exercise.
Indeed, and I think that those references to those sections are no more than, again, to the same point, they're no more than window dressing. I didn't make the point of a
But that as well as saying these various magic words, as well as talking the talk, the judge has got to actually walk the walk and apply the principles in the course of the analysis.
for there to be a confidence that it has been undertaken. And the only way of getting any attempt at a holistic analysis in this case is to refer back to other sections and to seek to say, well, maybe he meant that with that. In my submission, that's
None of these observations are to say that a judge who approached things properly would have come to a different answer or could have come to a different answer on the evidence. That's your ground one, is that yes, they could, they might. But it's certainly from my point, it's regrettable that the judge doesn't give us confidence, doesn't give me confidence that he went through the process in an adequate way.
No, and in my submission there was no proper attempt. And again, the point we made, this was an extemporary judgment, but there was no there was time. He didn't have to give an exemplary judgment that afternoon. I'm sure the court would accept that as a point. And he could have taken the time to do the proper analysis and to produce a proper judgment that read in the proper way. And in my submission, it simply just didn't happen. There's a lengthy recital of the written evidence he's got before him. I'll come on to the point about limited witness evidence, and then a short attempt at producing an analysis, which should be the bulk of the judgment in reality, and the focus.
If we're looking at paragraphs 46 and 47, the judge is clearly aware of the welfare checklist and mentions it in the first of those paragraphs, and in paragraph 47 refers to one of the significant checklist factors, which is ceasing to be a member of original family. I'd just like to understand what the substantial product is of your critique of the approach to the welfare checklist. What is it that in the end is fatally lacking, as you would put it? Had the judge set out in the judgment all the factors and gone through them, what is it that he's missed?
The point that I would submit he has missed in this case is partly joins the two grounds together, is that there is a limited analysis of risk that is then replicated with a inadequate analysis of how he gets to his conclusion.
But I mean, coming away from the critique of the process, what is it in substance you say is either not there or not demonstrated as a result of the way in which the judge went about it?
What I say is not there is an adequate attempt to consider whether these parents were in any way an option. If there's not a consideration of the pros and cons that they offer, then there is no, in my submission, balanced analysis as to a consideration of the case in any realistic form. You can't have any confidence in my submission that he has properly considered any of the real arguments that were put before him, or the substantive difficult arguments that were put before him, to have any confidence that the decision he reached on the evidence was the correct one. I can appreciate how, from a perspective of looking at negative concerning residential assessment report with comments of negative value from the psychological assessment, the court may say, well, there was a reason why he could come to some justification in respect of these. But the court can't have any reassurance in my submission that he undertook these exercises in any form. If he doesn't set them out, how does the court know that they were properly balanced? Him having had the argument made, he had the benefit of seeing the witnesses, he's had the benefit of being able to comment upon them as well, and he hasn't done so in any real regard.
Some of the points you've been making are really points under ground 4 as well, aren't they?
Except there's a lot of overlap.
I mean, so the ground 4 is too much emphasis on negatives, not enough emphasis on positives, isn't it?
The nature of drafting a quick permission to appeal document.
But I mean, I think have we been dealing with really grounds 2 and 4 in substance?
I was going to be far quicker with the latter ones.
All right.
And I think in part I could deal with ground 5 at this point in time, which is the linear analysis, which I may as well do whilst we're dealing with the substance of the judgment. In that, having identified the two parents as realistic options, there is then a dismissal of them within paragraph 46, without that balancing exercise being undertaken. That is, in my submission, the very heart of a linear analysis. I appreciate you have to, as the other cases would say, and your lords have commented in other cases, you've got to write it in a linear fashion because that's how it works. But it's obvious in his decision that the decision about the parents has been made at that point, because that's what he says, without then moving on to the actual balancing exercise, which for some unknown reasons I've already said he undertakes between long-term foster care and adoption, which was not the realistic exercise he was being asked to undertake. So my submission with respect of ground 5 is that this linear analysis is quite clearly set out, with the beginning of paragraph 46. And I can't understand how making evaluations thereafter between, as he says on the third line down of paragraph 46, between adoption and foster care allows you any reassurance that he hasn't carried out that linear analysis. If I move on to ground 3, and as I say, I'll have very little to say with respect to ground 4, I think, and now nothing with respect to ground 5. The strongest argument in my submission for the need for any form of transcript in this case is that there is very little, if any, reference. Well, that's wrong. There is very little reference. I can't go so saying any reference. There definitely is reference to some of the oral evidence. There is very little reference to the oral evidence.
So this is the balance between written and oral evidence.
Indeed. When the court considers the judgment, scrolling up the judgment to find that the actual reference is, certainly the first half of that judgment, all the way through, I think, to paragraph 27, is dealing with background and information that is set out in the papers. You know from paragraph 10 that there were a number of witnesses called. You have very little information in my submission as to what those actual witnesses said. Paragraphs 11 to 26, I think, deal with the written evidence. There are some fleeting references to what the
What about paragraph 23? It's an observation I made a short time ago. That seems to be the expert's oral.
I accept that, Your Honour. That seems to be in the middle of... That may be the only reference to oral evidence in the part of the conversations about the written evidence. Again, I appreciate it's a structural point, but it would certainly be better in the judgment to have the written evidence set out and then the information that heard from the oral witnesses. I accept that's a stylistic point and may not get me very far with respect to matters. But those 3 lines in paragraph 23, I accept, Your Honour, my Lord, must come from that, must come from the oral evidence.
More than 3 lines. Well, we went through this. That any reference to March or September, and indeed January and February, must be to oral evidence.
There were updating statements from the social workers and the Guardian after the March.
But this is Mr. Marshall's. This whole paragraph is Mr. Marshall, isn't it?
I'm not sure maybe being pedantic here, but 4th line down of paragraph 23 is not in relation to Mr. Marshall. That's a comment about other things that he has considered. It is worrying evidence of continuing involvement with drugs with the incident. The mother's statement he refers to. And then he goes back.
Right, okay.
So there's a reference to Mr. Marshall halfway through.
You say that the judge has pulled in different references in the same... Well, that may be right. Yeah.
But with respect of the fleeting reference to what the parents said, with respect of the lengthy cross-examination of the Guardian that was undertaken, that there is a single paragraph, a single comment, which again, my learned friend for the Guardian pulls out at paragraph 49. The Guardian gave careful evidence. I do not disagree with the Guardian's analysis. You have absolutely no idea from this document what challenge was put to the Guardian, what he said about that challenge, what he said about Dr. Marshall's evidence, for example, Mr. Marshall's evidence, sorry, what he also said about any other critique that was put to him, because that is the single line from it in respect of the Guardian. The limit of the comment with respect to the social workers cross-examination is that paragraph 33 on A39, just in relation to that single comment, single query around support that could be provided to the parents. There's no other reference to the social workers' evidence. There were 2 witnesses called in this case from the residential unit. They were challenged about the points that were in my opening note about the substance of what was said, whether matters were quite as alarming as were made out, what impact the dishonesty had. No reference at all in the judgment to what they said at any point in respect of the comments made to them. And then the subsequent questions that were raised of the Guardian about them. From the judgment, you would almost not know that they gave evidence about matters or were challenged on point.
The difficulty that we're experiencing that you're pointing out is that the judge has, as it were, interwoven written and to some extent oral material in a way that needs some unpicking. I mean, I'm just looking, for example, at the end of paragraph 17, where this is at the conclusion of a long passage which summarizes Mr. Marshall's evidence, and then, as it were, it's not entirely clear to somebody who wasn't there at which point he's citing from the report, and at which point he's moving into the oral evidence.
The point I was going to go to goes with relation to Mr. Marshall. There was a comment which I've referred to in my references document in relation to what Mr. Marshall said about the risk assessment that he carried out. He told the court that in the event that matters were 12 months ago, there was a substantial decrease in psychological risk. The court would have seen hopefully from the opening note I raised in that note that nobody appeared to have asked him what this appreciable period, the exact words he used were, what this period was. No one's sought to ask him, so understandably he was asked in evidence, and he tells us that information. There is no reference within the judgment at all to that piece of information being obtained. Particularly notable, given the events of the residential unit and the dishonesty with respect to the residential unit were some 12 months before we had that final hearing, or were very close to being some 12 months from that final hearing. I raised that point in the supplementary questions. I think is the first point that I made. Just find the exact reference for your Lords. I say on a 4.4b, little b.
These are the questions that were raised with him after his
the
original
judgment,
report. Yeah.
Yes, to see what have you considered these matters.
Yes.
4.4b.
4.4b, yes. I think that may be page 48 of the document, of the electronic document.
47.
I say there was no comment in your judgment with respect to what Mr. Marshall told us in evidence about the period of time of the 12 months. And then don't make much sense about what I was specifically, the transcript doesn't think I did, can't make substantive change. But he would have been more than aware of what I was referring to because it had been referred to repeatedly, as you would expect when an expert tells you that the risk has substantially decreased after 12 months of time, within all of the evidence. But there isn't, and the local authority accept within their documents that comment was made.
The extent of the recorder's response to that is on the following page, line 7, isn't it?
Yes, is that I've said things about February and March. I wasn't asking him necessarily to comment on the time ago, whether 12 months elapsed, but that comment, that question as to if substantive change or substantive reduction in risk occurs after 12 months, we aren't that far from the point of 12 months in this circumstance.
Well, that was clearly a major point of your case. Does it surface in the judgment at all?
The reference to that?
That Mr. Marshall said that if we see a period of 12 months,
I'll be correct if I'm wrong, but I do not think it did.
No,
which is why I
asked it. My recollection is that it doesn't.
No, which is why I asked about it. Have you considered this? Because inevitably that is an argument that...
I mean, it begs the question when the clock starts ticking and whether it has to include the therapy or not. You would say I think you would say the expert said it didn't have to.
Didn't, no. He made it.
But the therapy was not going to be a cure, but it was a support for the parents.
It came to the balance of risk argument that we started.
Yeah.
And it wasn't factored in. So in fairness, it wasn't factored into the written evidence of any of the parties because they hadn't heard it. I think the critique I make in the opening note is they probably should have made that query if an expert's telling you a substantive period, asking what he means. Yeah. Nobody did, but he was asked in oral evidence, and all of the other witnesses, as the local authority's closing submissions make clear, were asked about it. And the judge makes no reference to quite an important element, I say a very important element, in relation to the oral evidence. And that goes back to, this is an exercise that appears to have been done, a written analysis broadly of the professional witnesses, certainly, on the paper that he saw, rather than recounting before the court in the judgment what he was saying about the oral evidence that he'd heard, because a proper analysis of the oral evidence that he'd heard would have contained that quote. It's so important it appears in the local authorities document, because they are thinking we need to address this point, because otherwise Mr. Williams on behalf of the mother is going to do so. So that was in my submission, is the heart of ground 3 is the failure to consider oral evidence, but that is a key factor of it that for no explainable reason was not in the judgment, and then he doesn't even seek to quantify it when asked a question about it, other than saying, well, some of these events are less than 12 months ago, so what's the problem?
Could we just, with half a mind to the adjournment application, look at the supplementary bundle at page C239, which is electronic 428, which is the local authorities.
239.
Sorry, I should have taken you to that. That's the quote.
Electronic 428.
Penultimate paragraph on that page.
Yes, no, I mean, we obviously had this in mind. So this is the local authorities' commentary and some summary of Mr. Marshall. And that reference to examination in chief, reference no doubt to some matters that arose in cross-examination, and page and a half or 2 pages on that topic. Does that represent as it were, a broad overview of Mr. Marshall's evidence on these issues? Within the limits
permit me to cross-reference that to my note. Difficulty, but
no, I'm not seeking, as it were, to tether you to that.
Yes.
But it's the paragraph below the bullets, isn't it?
Yes.
But I was asking a slightly wider question, which was to do with the question of whether the representative who made that summary made a summary which you would accept as being overall fair in regard to Mr. Marshall's evidence, or whether you have any particular reservations about it.
I was going to highlight to this court the 2 paragraphs, the paragraph I've highlighted and the one above where I'd made reference to the positive comments.
Yes.
I'm perfectly happy to answer my Lord's question, having had a chance to look at it in more detail. It's difficult for me just to say.
Because it's obviously, so far as Mr. Marshall is concerned, it's having read his reports and supplemental and so forth, written material, and the Amber House document where we then go on to the 2 Amber House witnesses. This is our best record of the oral evidence, including the social workers' evidence, which then follows. So we have 5 or 6 pages. It covers all of that from the local authorities' point of view.
And that's my only wariness, is that you write written submissions for a purpose, which is to persuade. And I'm not suggesting the local authority would have sought to mislead the court about matters, but they may not have included the fullest of summaries because some of the matters that I may have thought were relevant were not included. So I've got my notes of the previous hearing, and I've got my notes of what submissions
No, but I mean, I think it's at some point, and I don't want to ambush you on your feet, but at some point you're going to need to tell us, well, please don't accept that as being a global view of this evidence, because it misses this striking answer, as it were, which should have been in that summary. Because, of course,
certainly the striking answer is there, and that's why I'm slightly more reticent and just saying it's not good enough, because I know the striking answer is there, and that was
which is the 1 year.
Which is the 1 year point, yeah. Well, the 1 year and then the 2 year point, the substantive reduction.
And it's according to the summary, the caveat that Mr. Marshall put on it was that bottom of page, internal page 12, he accepted the parents could evidence some positive change, but it was clear that if the court found that either of the parents had continued to be dishonest, that would raise his concern, as did the incidences of the father expressing angry responses. So did the judge make a finding that the parents had continued to be dishonest?
There's no reference in his judgment that he made. Well, that he that's what I'm unclear about with respect to the case put by the other parties. There's no findings were sought at the lower court with respect of ongoing dishonesty, save for what was accepted. And that's why I referred to you previously about the January rental car and the acceptance with respect of the November attendance of the third party. There were no other findings sought, and that's why I was able to make the attempted positive list of positive attributes, which included the length of time for dishonesty. We've already gone through whether that's...
Well, no, but it's... I mean, you say apart from, but I mean, paragraph 41, they've been deliberately been dishonest about continuing contact.
Is my Lord's question in respect of that whether there was this third party was still in communication with them?
Well, it's not only that. It's also paragraph 43, which is continuing deception. I don't say this to push back against the points that you've been making, except insofar as they as it were, say, well, the judge didn't make a finding that the parents had been dishonest.
They have been deliberately. Yeah.
Well, you've got at 43 in the final sentence that the parents continued to be deceptive.
Yes, that's what.
Coming to the same point that we're making with respect to this ground, there was no oral evidence, there was no finding being sought by the local authority, my understanding, in relation to continued dishonesty. Inevitably, for obvious reasons, I'd sought at the outset of the hearing to establish what factual basis the local authority were relying upon, and then to put those to the witnesses.
If somebody is thought, whether rightly or wrongly, but is thought to have been dishonest for 7 years, it doesn't get you very far to say that, well, there's no particular evidence of dishonesty for 7 months. I mean, surely.
I'm not going to argue about that. But there was no specifics sought of an ongoing relationship between these parents and the third party. That is the relevance of the 12-month point of. There was no evidence of any communication with this individual, nor was it sought by way of a finding about any additional information being sought about phone records, etc., to any ongoing communication with this third party. And that was the relevance of, if we're dealing with a risk management about this being the only risky individual that anyone could point to with respect of these parents, even that risk, if indeed he was the perpetrator, which I accept is the difficulty with the findings that were made, the Paul finding, there was no identification of him as the that risk, of having that also had passed that 12-month point. Just checking as to whether I had any other matters to make substantively about this submission. I appreciate I've been on my feet for a long time. The only other matter which is referred to in the Guardian's closing submissions, and this is at C247 of the supplementary bundle. No, it is 247, sorry. It's internal page 436 of the supplementary bundle.
So it is C247.
It is C247, yes. These are the closing submissions put on behalf of the Guardian's representative. I've already made the point about the lack of reference to the Guardian's oral evidence. There's an acceptance on the 4th bullet point down of this. There had been a change. No evidence of recent concerns. More balanced now, but recommendations, remain as must balance with other welfare factors. There's no reference.
And must balance with other welfare.
And must, sorry. Yeah.
But
whatever the note, whatever the purpose. Similarly, with respect to the only other reference that was of relevance was a critique was made of the Guardian that he appears to have reached his conclusions even before the ADM had taken place, I think, in the case. I can't remember the exact reference, and that's the reason why there's that further comment further down. But it's that 4th bullet point down that there's no reference in the judge's analysis to this guardian accepting that his view was now more balanced than it was previously, and this case was a more finely balanced matter than had been previously. I don't deny that he continued to support the plan of the local authority, but it is an important balance in my submission for the judge, for even the guardian in the case, to be accepting that there is a movement, positive movement forward that needed to feed into the balancing exercise that I referred to with respect to the second ground. And it doesn't appear in the judgment.
The guardian last provided written evidence in March 2021. And we have it in the supplementary bundle with an analysis at page 179 of the electronic bundle B94. What's your submission about the extent that the guardian's oral evidence stuck to the analysis in written evidence, or the extent to which it in any way significantly differed?
The guardian was challenged about this page.
Yes.
And that this seemed, submissions that were made, as a relatively succinct summary of a welfare analysis. If this is his analysis of parenting capacity, the criticism that was made were both of these, social worker and the guardian, relied heavily on negative reports, to use their term, from both Amber House and from there. So he was, I'm struggling not to give evidence, which is the difficulty of it, partly because I can't entirely always remember the entirety of it, but also with respect to the rules. There was considerable challenge put to this analysis and to the scope of it that appears nowhere within the judgment, and you don't have before you. All you have is that comment of. And it was the critique made in opening and throughout was this was a simplistic analysis by both social worker and guardian of two negative assessments equals needs to be a placement order, and pressure was placed.
I mean, obviously one has to read the document fully for its effect, but I'm not yet understanding why you say it's a simplistic analysis. But I mean, it's a 15-page document, and it's there, says what it says.
Because there was no attempt within the written evidence of both the social worker and the guardian to explore that balance of risks that had been asserted. So what did the residential unit say of specific value that meant they couldn't care? It was just there is this report, therefore I have that conclusion.
But that's not what is being said. The guardian is for himself going through the sorts of issues that arise in the case. I mean, obviously there may be challenge to it, but insofar as you're saying, well, the guardian just said psychologist negative, residential assessment negative, end of. I'm not quite sure. That would be simplistic.
Yes. The difficulty comes of you don't have the challenge that's made as to those reports to try and dig below this report and to the sticking to it of that, particularly because you don't have any details information with respect to what the residential unit said about their assessment. So you've got their report, I appreciate my lady, you've got their report, but there was criticism made of that as to try and explore what those specific conclusions meant. Was it the dishonesty of the father in November that led to a whole-scale change in the attitude of the placement and the ways that the parents then, the scores that they then got thereafter? You have none of that challenge, and the difficulty for cases is that was a more positive outlook, I think, was my submission about the residential unit at the conclusion of that cross-examination than there had been at the beginning. An explanation as to, and the judge makes fleeting reference to, you can do one thing wrong and you get an amber mark on this score sheet too, it's red.
Yellow card.
And that was the type of analysis that was had of these things, and lots of them had to remain amber
your
because they've been previous.
submission, which is you can't make good because there's no transcript, but not only was there considerable challenge to this analysis, but that you got somewhere in the challenge, that the guardian moved in his answers to a degree in your favour. Is that what you're saying?
The Guardian was more, he accepted himself in the closing submissions that there was a more balanced approach than previously. That in part was brought out by challenge on both the parents' account, but also on behalf of the questions put of the expert witnesses in the case.
Secondly, I think you say that the Guardian's analysis, having been challenged in detail by you on behalf of the parents, it was insufficient for the judge simply to say the Guardian says this and I accept it. The judge should at least have acknowledged the fact that the analysis was challenged and indicate what his conclusion was about that challenge.
Indeed. The barest information that should have been contained is that the Guardian accepted a movement forward from his analysis. I would submit. Similarly, there needs to be some reflection of what points were put to the Guardian so that he can rely upon his conclusions. I heard from the Guardian, he said these various matters, he was challenged on these points, and I still favour his account. But there needs to be, in my submission, some level of detail as to what the Guardian was asked about, and indeed the social worker. The only reference you have to any of the there were 4 days of evidence in this case, sitting approximately 5 hours a day. Yeah. The social worker gave evidence for probably the bulk of a day. The 2 other witnesses gave evidence extensively. You have so little of what they said in the judgment, in my submission, is a failure by the judge to reflect what he heard before him, rather than what he may have read in the paperwork when he came into the case with his pre-existing views. What otherwise was the purpose of all these people being there asking these questions if that then doesn't form or shouldn't form part of a global analysis or a judgment supporting the decision that he came to? I accept the difficulty with the transcript is that you don't know what it was, but that in essence is the problem with the judgment. You don't know the rationale behind what these various people said because you don't have any comment with respect to the negative comment. I mean, there's no sign from that document that any progress was made with any of these witnesses. I mean, the only comment with respect to the social workers, there was questions asked in cross-examination, he stuck by his original view. I accept what the Guardian says in his evidence. In my submission, a balanced analysis should have that. I heard challenge on these points, but these are the reasons why I still favour the position.
Well, in terms of a fair hearing, part of that is for the party that loses to understand that at least they've been heard. And I think you would say in relation to this judgment, there's no real acknowledgement that your case, the parent's case, was heard and understood by the judge, albeit that he rejected it.
Indeed. And that is what is missing in my submission from the judgment, but that's what goes to its error in that there can be, on the parent's behalf, no trust that he properly considered any of the matters raised. I mean, the omission of Dr. Marshall's point is a relevant one, but I raised other points in the additional questions after him in relation to the balance of risk. And there was another one I raised, I immediately can't remember, but to be asking quite simple questions of have you considered the expert in the case's sort of headline information he gave us, have you considered a balance of risk analysis, are quite stark questions to be asking a judge at the conclusion of a judgment, having just heard it, and to get very little, if any, response to it. And so for all those reasons, I would submit that the appeal should be allowed on that third ground. I just want to check whether there's anything else I want to say with respect to the fourth and the fifth ground that I haven't already covered. There's only one matter in respect to the fourth ground that I haven't raised. It's a matter in respect of the father. There is a reference at paragraph 41 of the judgment to a continued, father has continuing contact with people involved in drugs. This is the point that I think the ground refers to, is there's a focus on some subsidiary matters. Say for the March incident, where he had, by the father's own acceptance, purchased drugs for a different service user at a property of some form, I can't remember the exact information. There was no other evidence of continued use of drugs or continued involvement with drugs. There was no finding sought by the local authority with respect to drug use. There was no critique made of the parents about them being involved with undesirable individuals who use drugs. This comment, I think, was raised by Mr. Anderson in queries that he'd picked up afterwards, is because it comes out of nowhere, particularly. And it's, in my submission, just further evidence of a lack of balanced analysis, not considering the positives that have been set out and I've dealt with, but just bringing out unsought findings. I appreciate courts can make findings in respect to matters that aren't pursued by the local authority, but there would normally need to be some evidence given with respect to it. And there's no explanation as to how he can come to a conclusion there was a continued involvement with people who were using drugs when nobody had asserted that there was. And it's just a further evidence of another negative being used in absence of any positives being analysed. And I think I've dealt with paragraph.
Can you, as you stand there, take us to the primary source of that comment about continuing contact?
Primary source for this paragraph 41.
Yes, I mean, I remember there was some odd incident that that had led to it, and the fact that the judge relied upon was something that the mother had herself accepted had happened. Although I appreciate there was some controversy about the backstory to why this had happened. Do you have readily to hand the?
I think it's in my client's final statement.
I'm thinking more of the case that had been raised against him or her.
There was a global acceptance by, I think, the father in his statement.
Yes.
The reference rather than just telling you what
Did this come from the social worker's last filing?
I think it post-dated. So the one matter that hasn't been raised, I think is raised in Mr. Anderson's document, is about there was inclusion within the bundle of material that parties had accepted shouldn't be in there. There's references to some form of sexual misconduct that local authority didn't seek to prove, and at an earlier hearing was agreed it would all be removed. It wasn't, and the judge saw it. He said at an earlier part of the hearing he wouldn't take any account of that. He would.
Right, is this? I'm sorry, I think I may have run it to ground. Is this in the supplementary bundle at B59?
E50.
B59, which is electronic 144.
Thank you. Yes. Yes. So this is the March 23rd March 2021.
This is the instant which the judge is referring to, not for the sexual element of it.
No.
Because is that the bit that you say was excised from consideration at an earlier stage?
There was, in the original bundle, I think actually, if you've got the original bundle, there are a number of pages that just say removed or redacted. So that had happened, but for some reason no one had edited the statement to remove references from the statement to the parts that were in exhibits. So those weren't considered, and I don't suggest the judge erred in that way, because it made no reference to it. The way in which I do say he did was that this B59, 23rd of March, it was accepted by Mr. Brown that he had purchased cannabis, I think it was cannabis on that occasion for a user in the premises, but there was, and he accepted that happened, didn't use it himself, but there was no other instance afterwards. So my critique was, how does the judge come from no one sort of finding with respect of ongoing involvement with any of these individuals in this property? They'd moved out, I think, subsequently and moved to their own accommodation. There was no factual basis for the judge to then seek to say this is continuing, because no one was suggesting it was. It was just an instance of concern to the local authority amongst a greater array of concerns that weren't considered by the judge. Checking my notes with respect to ground 5, but I think I've made the broad point that the analysis, when considered, is in my section.
I'm so sorry, Andrew. No, thank you.
The only other point I had with respect to ground 5 was the partly feeds into other ones, which is the lack of. The other point I make in ground 5 is that there's a lack of focus on the submissions that were made before him. I appreciate there was submission made with respect, and he makes reference to submission being made with respect to an adjournment. There was reference made within those submissions to the testing in re-S before Mr. Justice Mumby, which I accept, and again is in the authorities bundle, which I accept is a family drug and alcohol test generally used, but a sort of 3-stage test setting out 3 questions need to be addressed. This is page 38 of the authorities bundle. It's also paragraph 38 of that judgment. 3 questions: solid-based evidence that the parent is committed to making change. Is there some evidence-based reason that the parent will be able to maintain that commitment? And is there some evidence-based reason to believe the parent will make the changes within the child's timescale? That test specifically referred to the judge. Examples given as to why criteria were met with respect to those. And there's no attempt within the judgment to consider the test that he was taken to. Just a broad-scale therapy is not a panacea and can't resolve matters, rather than a proper proportional analysis about that point when raised. In a case particularly focused on, if 12 months there is a significant reduction in risk and we are close to it, and you have the therapy, what is the downside of having those further delays? And again, those points put to guardian and social worker in cross-examination. On that point, there was some, again, this is the benefit of a transcript would be, is there was some movement from the guardian about that, but I can't go any further than that because that's giving evidence. I'm not going to. I've been trying to be cautious as much as I can because I appreciate all my learning friends who
because
weren't
you've
there.
admitted you're not necessarily a fully reliable witness.
It probably could be if I read the documents in detail, but it's November of last year. Save for that, I don't think I have any other matters that I wanted to raise.
No, well, we haven't got any to raise.
Appreciate
With
it
you.
being
Very grateful to you, Mr. Williams. Now, Ms. Limbury, clearly we've allowed Mr. Williams a deal of time, and I don't regret that because it's enabled us to traverse a lot of the ground, which is, I think, common ground between the two parents. And so, do you have any, just looking at the clock and just planning the rest of the day, do you have any feel for how long you may need to add the submissions on behalf of the father?
I would have thought I'd be done before lunch.
Right. Well, that's
I intend to be quite brief.
good. Well, let's aim for that.
Famous last words, but that's
No, well,
the
then
intention.
we've made a careful note of what you just said and of your name.
My Lord, I want to be clear at the outset about what this appeal is and isn't about. This is not a case where the appellants are challenging an otherwise sound extempore judgment because it could have been better and could have included more. Our case is that the judgment, as it stands and as the court has been poring over for the last hour or so in detail, does not reveal careful, considered analysis on the part of the judge, which needed to be there given the significance of the decisions he was making. In my submission, he failed to properly consider issues which needed to be dealt with. My Lord, I adopt the distillation of the grounds of appeal that was given by Lady Justice King in granting permission. That is at A45 of both bundles, in fact. And in essence, I will pursue 3 submissions. The first is that the court failed properly to take into account significant changes made by the appellants, and I say from 2020 rather than from 2021, which is what Lady Justice King had said. Second, that he failed to recognise the impact of those changes on the balance of risk. And third, that the welfare and proportionality analysis was flawed. I hope to clearly signpost where I'm going because I'm conscious that your lordships don't have a skeleton argument from me. In terms of the first submission, which is that the judge failed properly to take into account significant changes.
I'm so sorry, I was writing down the points, the 3
I'm
points
so
you were
sorry.
making. Would you mind just doing 2 and 3 again?
No, I apologise, that was quick on me. The second was that he failed to recognise the impact of those improvements
Yes.
on the balance of risk. And third, that the welfare and proportionality analysis was flawed.
Thank you.
And in terms of that first submission, I pursue 3 points. The first is the concerns. I would confront those. What were the concerns the judge had to address in these proceedings? Second, what was the significant change that I'm alleging? And third, how did he fail properly to take it into account? I would ask, in dealing with what the concerns were, that your lordships turn to D16 of the bundle. This is the supplemental bundle. and it's the judgment of His Honour Judge Lee on the 25th of November 2016.
That was B16, was it?
Apologies, D16.
D16.
And I won't read it all out in full, but to take from paragraph 23 onwards, the court can see the sorts of issues that His Honour Judge Lee considered both parents gave the court at that time. In broad terms, it was their attitude and acceptance of the findings he'd made back in 2013. At paragraph 25, the father's refusal to accept it was an accidental injury. At paragraph 27, the father's refusal to accept that he'd ever parented mother's elder child inappropriately. At paragraph 28, his concern that the parents had an inflated sense of the standard of their own parenting. They did not accept they were not good parents. And at paragraph 32, the father's use of cannabis, which over the page, at paragraph 33, was noted to be a very, paragraph 35 was noted to be a very significant risk factor in this case. He then went on at paragraph 39 to identify the parents as paying lip service to the need for change. And at paragraph 40, the parents being enmeshed in the same relationship with the other potential perpetrator, Mr. Kelly. My lords, for reasons of time, I won't take you through it in detail, but if you look at C93 of the bundle, which is the final parenting assessment of Miss Wally, at the start of that document, it essentially mirrors the concerns that I've just identified. So it shows that at the beginning of these sets of proceedings, the local authority was expressing concerns about the same matters that His Honour Judge Lee had identified.
Because when they were instructed, they were given that menu of problems, weren't they, to consider? Both Aberhouse and Mr. Marshall. I think
Yes.
in the commissioning of their assessments, what you're looking at here is carried through to that.
That is right, my lord, and I would say it wasn't just a reference to the background, it was rather she was setting out this is what the local authority is concerned about now.
Yes.
So I say essentially this was in essence the evidential landscape the parents were facing. These were the hurdles they needed to surmount. Which leads me to the second element of this ground, which is that I say they did in fact surmount some of these hurdles within these proceedings, and I say to a significant degree. First, I will address the father's use of cannabis. That was, as I've said a few moments ago, identified as being a very significant risk factor. By the end of these proceedings, it was accepted by the local authority, and this is in their closing submissions at C237, that the father had not used, or there was indeed no evidence he had used cannabis from about September 2020 onwards. That, in my submission, is evidence of a significant change when one remembers that this is a man who had been using cannabis on an almost daily basis from about the age of 13. In the ordinary dictionary sense of the word significant and change, it satisfies both those definitions. The second change I would refer to is the parents' relationship with Mark Kelly, who is, of course, one of the third protagonists in this case, if you like. There is no evidence from November 2020 onwards that either parent had any contact with him whatsoever. And again, the local authority accepted that at C237. It showed that the parents were able to extricate themselves from that dependent relationship which had subsisted for a number of years. And the fact that they did not go back to Mr. Kelly, even when they were made homeless, effectively following the parenting assessment, is indicative of the strength of that change and their motivation to maintain it.
What was the date you gave us in 2020 for that?
I think the last contact was the 17th of November 2020, and that was what was referred to about the father having communications with Mr. Kelly about his dead cat. But after that, nothing further, and the local authority accepted that. So that was undisputed evidence before the judge at the final hearing. The third change was in terms of home conditions. The parties had acquired private rented accommodation in about March 2021. The local authority conducted one visit during the lifespan of these proceedings in June 2021 and confirmed at B58 that the home conditions were satisfactory. In the original proceedings, that had been a big source of concern because the parents kept a number of cats and essentially were not keeping them hygienically, and I'm sure your lordships can fill in the detail of what the home conditions were like. But things have moved on. The only comment the local authority made was that there was some clutter, but that was attributable to the property being small. The fourth change I would address is lifestyle. The father has acquired permanent stable accommodation as a DHL delivery driver. That was from April.
Employment, not accommodation.
Oh, apologies, yes. From about April 2021, he had managed to clear most of the housing arrears on the party's previous property. And I draw on this point to say that it would have been in the judge's mind that had the child been returned to them, they would have been parenting in different conditions, much better conditions than those in the earlier sets of proceedings. I touch lastly on the difficult issue of the parents' insight, and I accept that is a difficult issue and it clearly gave the judge pause for thought. But I do say that insight had developed from 2016. Various examples for this in respect of the mother can be taken at page C45 of the bundle, which is Mr. Marshall's assessment of her. And I read out, just for purposes of time, that the mother accepted she had not looked after her oldest daughter properly. She accepted that her daughter, as a consequence, was not able to share her feelings with her. She accepted towards the bottom of that page that her routine had lacked structure and that she pushed her elder daughter away when the new baby came along. And over the page that there had been a lack of toys and a lack of playing with the children. The father, for his part, within the same assessment, accepted from page C71 onwards that he used to shout at the mother's eldest daughter. He grabbed her arm, but he didn't drag her. He accepted at C72 that he'd smoked cannabis in front of the daughter. At C128, that the home conditions were horrendous. On that same page, that the way he spoke to the eldest daughter was not right, and that he should have got the children out of the third party's house. He followed that up by saying in his statement for the final hearing at B41 that he now fully accepted the findings the court had made. In my submission, this shows that both parents had moved considerably from their position from the 2016 proceedings. This is not a case in which they were making bland statements of acceptance. They were actually able to articulate the ways in which they had been inadequate at that time. So there was a movement in terms of insight. They were not putting blame on the local authority or on third parties. They were holding their hands up and saying, this is what we didn't do, this is what we should have done. In my submission, the best evidence of insight is action, and this was the parents' action. They were responding to what the previous findings had been and demonstrating that they could change their ways. And whilst criticism was made by His Honour Judge Lee that the parents have never fully articulated in clear terms that Mr. Kelly was a threat as such, they have demonstrated their perception of him as a threat. They've stopped living in his property. They've separated their lives from his. That is the best evidence the court could hope for, in my respectful submission.
But it's not established that the threat comes from him. I appreciate the parents have got to deal with the case that was decided back in 2013. But that's only one facet of it, isn't it?
It is.
It's an unknown threat source.
It's unknown for the court, but it will always remain so unless somebody comes forward and says, I was culpable. The parents can't do that because they say it wasn't either of them and they don't believe the other did it. They've formed the clear conclusion that it was the third party. And they've now shown the court that they accept the risk arising from it being the third party. And that's why they've now extricated themselves from being in a relationship essentially of dependency with him. I say that these points were not taken into consideration in the judgment. That is my third point on this ground. My Lord will know that because they're not explicitly referenced in the way that I have just addressed. And although it's said in a bland summary that there was some evidence of change, certainly the judge did not go through it in the way that I just have, and I accept that he wouldn't have necessarily to do so, but he doesn't create a clear impression for the reader of the extent of the change, that it was the parents accepting culpability for their own wrongdoing, and that insight would have an important impact on risk, future risk. What he did do, which I say was wrong, and A38 of the judgment is an example of this. Apologies, in fact, I think the reference may be elsewhere, I'm struggling to find it, but what he did do was he started to dilute any positive change that the parents had made. So, for example, father's cannabis use. That, as I say, was a significant change. By the time of the final hearing, he'd been abstinent for over about 11 months. He diluted that by then referring...
More than that.
Yes, apologies, I was just reflecting
September
myself,
20,
that's wrong.
it's not much more, but it's more than that. It's 14 or so.
It is, that's right. That's my maths. He diluted the effect of that change by then referring to the isolated incident in March 2021 where the father accepts that he purchased cannabis for a third party. Now, plainly, that was an unwise move on the father's part. I would accept that. But it wouldn't be enough to say that the substantial change in respect of drug use had now resurged itself and was now a problem once more.
Paragraph 30 is perhaps the key part of the judgment that deals with this element, isn't it?
It is.
That's the first 3 lines.
And I think that would go to Mr. Williams' broader point that there was a lot more to this hearing that one doesn't get a sense of from reading the judgment. And I'm quite sure that these are the sorts of points that will have been put to social workers, put to the Guardian, and put to Mr. Marshall in evidence. Well, what do you say about all of these changes and how that impacts on the risk? And I'm sure they will have given responses to that. The court doesn't have. The issue for this judge giving this judgment is that we don't see any of that. We don't see that process or that consideration. We just see a bland statement. The parents' contention is that they've made and sustained changes. The evidence is that he doesn't accept it.
Can I ask this? And I apologise, I'm being pedantic.
No, not at all.
I understand what you're saying about the judge's dilution of the point of the father's stopping the use of cannabis. Is it accepted that there is only the one incident involving a third party?
Yes, I believe that the evidence for that is in the local authority's closing submissions.
It's just that at paragraph 41 of the judgment, it's the third line up, father has continuing contact with people involved in drugs. That's quite a general statement. I was just concerned what evidentially the evidence is.
Well, my lady, that's my concern, that it does create the impression that the judge must have thought that there was some sort of ongoing issue with the father and drugs, which the evidence didn't support. And the local authority reference is C237.
Did you say B237?
I said 237, but I'm just wondering if my reference may
Is
have
that
been
C237?
It is, yes, you've got the penultimate paragraph. The local authority must accept there is no evidence of cannabis use by Mr. Brown since September 2020. That's that.
Yes, my lady, that is the passage on which I rely. And I know my lady may say from that, well, the fact they don't have any further evidence of it doesn't mean it's not going on the ground, but the court can only confront the case that the local authority chooses to present it with, and the local authority had effectively conceded that there was no evidence of that ongoing usage or involvement.
No, I take your point at once about no evidence of ongoing usage. My concern was the general statement by the judge about continuing involvement with those, and the court's attention's been drawn to one incident.
My lady, in fact, you've helped me in raising that point because there was only that one incident in March 2021.
That's the one. Yeah.
So it's that.
There's nothing else at all, is
No,
there?
and I'll be corrected if I'm wrong, but I've read everything, and that's the only reference that I can see.
Thank you very much.
Which does, as my lady say, create a rather misleading impression of the father and drugs from his claim period of abstinence. And I would also note, I suppose, the obvious point that the local authority could have asked for hair strand testing at any point. My client was always willing to submit, and they chose not to. So they clearly accepted that for the local authority, drugs were not a main aspect of the case. Again, something significant had fallen away in the case against the parents. I move then to consider my second submission, which is that the court failed to recognise the impact of those changes and improvements upon the balance of risk. As your lordships will know, the key question the court had to tackle was, what is the risk to this child? What is the likelihood of it arising? And what will the consequences be if that risk does eventuate? I say that the first question, what is the risk, has difficulties from the outset because those are not apparent on the face of the judgment. The worker at Amber House Residential Unit at C142, in her final parenting assessment, had accepted that she did not believe that the mother or father would ever intentionally harm the child.
So is that in the oral evidence or in the written evidence?
My apologies, my lord, this is in her written report, her final parenting assessment. And the sentence is, I do not believe that mother or father would ever intentionally harm the child or intentionally place him in harm's way. And I say that that second comment, not intentionally place him in harm's way, is itself significant because it gives rise to the implication that they would not take risks with the welfare of their child. On the same page, the worker accepted that the child's basic needs had been met to a high standard, that little hands-on help was required, that he was always clean dressed and warm, so there were not concerns about basic care. There were not, on this worker's comments, concerns that they would deliberately place this child at risk of harm. The concerns appeared to be more, in terms of the parenting assessment, that they were not able to consistently implement parenting skills. The concern was not that they didn't have those skills or were not able to put them into practice. The issue was that they didn't do so consistently. And in my respectful submission, Mr. Williams' opening statement sets that out very well. And he goes through the parenting assessments in quite some detail. I'm not sure if it will assist your lordships to linger over, but I would just raise in passing that some of the concerns identified within the parenting assessment may be classed as potentially weak and holding the parents to a higher standard than the good enough parenting, which is what they were being assessed against. And by way of example, the parents were criticised for taking their son to a garden centre before Christmas and having him held by Santa and his elves because of the risk of COVID. This might be the only Christmas these parents were ever going to have with this child. There was no consideration of that. There was concern about parents potentially texting too much or being on their phone. Well, that's only a concern if it means that they're not paying attention to the child or they're neglecting him. I'm not quite sure that that shone through in the assessment. But the judge chose in his judgment to linger over some of these points. Just by way of example, I have in mind A39, apologies, of the judgment. And it's interesting to note that whilst the judge hasn't, in my respectful submission, taken care to set out the positive changes made by the parents, he has, however, taken the trouble to set out the negatives. So he does set out, despite only having the opportunity for an extemporary judgment, paragraphs dealing with the incident I just referred to at the garden centre, the incident about mother bumping heads with her son and instinctively checking herself first, and about the parents putting the child to bed when he didn't appear to be particularly tired. None of those sorts of concerns would, I say, give rise to an order that deprives this child from growing up in his natural family, but these are the concerns that for the judge were significant. The judge did address the likelihood of risk, despite not being clear as to what those risks were, because he clearly took the view that these parents were a significant risk in some undefined way. And to conclude on this point, I would say that consideration of the consequences of risk arising was also inadequate. The judge did not give careful consideration to the degree to which any risks remaining could be mitigated. And again, in my respectful submission, I say that's because he did not take care in the first place to clearly set out what the risks were. Reading this judgment, one would struggle to answer the question of what concerns were going through the judge's mind. Were that child to be returned to his parents and put on their doorstep tonight, what harm did the judge think would befall that child? That approach fell short of what BS requires in my respectful submission. The court did not give careful consideration to what sort of services could be implemented to assist the parents if there were ongoing issues. He was required to. He simply said, well, the local authority have looked at this. The parenting assessment provided daily ongoing support and that wasn't enough. Therefore, that's the end of the matter. That wasn't enough in my submission. He needed to drill down to what practical support the local authority could offer, having first identified the risks, and then go on to consider it further. But it's clear that the moment this parenting assessment came back, the shutters essentially came down in the parent's case. The Guardian, as far as I can see, didn't even file a final analysis, despite the fact there had been 11 months since the last report to the final hearing. The case was effectively considered over at that stage, and that's also the sense one gets from reading the judgments. I will be, apologies, there was one further point I wanted to say on that.
I think we looked at a Guardian report in March. It doesn't matter particularly.
I have
but,
it, yes, apologies. But still, I would say
I understand the point, but just as a factual.
No, my lord, you're right.
So your third submission is about the failure properly to analyse.
That is right, my lord. I was going to make one very brief point before concluding on my second ground, as it were, and that's simply to say that when you read the judgment, you get, or I would submit, one can get the overwhelming impression that the judge thinks these parents are essentially a hopeless case and that they can't sustain change and they're not going to be able to care for a child. But there was no good reason for the judge to be unduly pessimistic. Both these parents, in their separate ways, have shown capacity to change their lives in significant ways. There are the ways I've just set out, but in addition, there is also, for example, in respect to the mother, she was previously in a very abusive relationship for a number of years, and the court may have seen some of the detail of that in the documents. She was able to extricate herself from that relationship and move on. She was able to address the concerns of the past. Similarly with the father, he had a criminal record when he was younger, mostly for theft and similar offences. There isn't anything that I have seen that shows that he's engaged in criminal conduct for the past 10 years. Certainly he's not been convicted of anything. So it does show these parents have it within them to make sustained changes. And that was something that I would obviously say should have been flashing through the judge's mind at this hearing. I will deal very briefly with the third submission because I do consider this has been dealt with well and in detail by Mr. Williams. And it's simply the point that the judge did not engage in the required welfare analysis and the proportionality assessment that he was required to do in law. He did not set out the various pros of these parents caring for this child, which I have just referred to. He referred in some quite bland terms to the fact that the parents love their child. He didn't go into great detail about the fact that contact has been of a good quality. No concerns have been raised about that after the residential assessment concluded. They've gone on to maintain a very good relationship with their son, which would be lost, of course, in the court making its final order. So whilst the judge said the right things in terms of quoting the relevant sections of the Act and said the word proportionality, in the final analysis, those tests weren't in fact applied or brought to bear on the facts of this case. My lords, I appreciate this is not going to assist the court to resolve the question before you today, namely whether the judge was wrong to make the orders that he did last November, but my client does want me to raise with the court that both parents have undertaken the therapy that was recommended. They started that indeed before the final hearing, I'm told, and that's coming to its conclusion quite shortly. So the judge had that recommendation from Mr. Marshall. That would have been a consideration for the final hearing. It was his professional view that the parents undertaking that assessment would essentially develop the ability to have reflective reasoning, so their insight into past concerns may grow further from what it currently is at present. He didn't consider therapy in any great detail within the judgment at all, because by that point he'd already excluded a return to the parents as an option on the basis of the flawed risk assessment in my respectful submission. The parents were ruled out prematurely. And I know, having raised those points about the parents making positive changes and doing therapy, that it may be said by my learned friends, well, they could make other applications, they could apply for discharge, they could apply for revocation. Those submissions could be heard in that context. I don't accept that. I say that these were considerations the judge needed to address at the time, head on, and he didn't, and it's not apparent from his judgment that he did either. Unless I can assist the court further, I'm conscious I've been talking quite quickly and for quite a long time.
No, well, nothing from me. You've been talking very effectively, Ms. Limbury. I think that's the takeaway from what you have said. So that's obviously a convenient moment. Ms. Guha, how long do you think you and then your Ms. Moore will need?
My lord, I would estimate between 20 and 30 minutes.
Right. Well, we'll obviously easily conclude. Clearly, because you've seen this, we haven't discussed the matter. For a concern I have is that if the judge's approach in his judgment is thought not to be adequate and compliant with the law, there's an if there, and you're going to make submissions about that, an approach of an appeal court might be to say, well, that's highly regrettable, but on the evidence, the outcome of the case would inevitably have been the same, and an appeal is against an order, and that there is nothing to be gained by sending the case back for rehearing. Something for you to consider is the difficulty we have is that because the submissions have been made, we do not know all that the judge had before him because we haven't got the transcripts of the oral evidence, and the points are being made that the positives aren't in the judgment, and so it's not possible to say as night follows day, it will be argued by us, that any judge would have come to the same conclusion even if they'd approached it in a different way in their judgment. So that's a difficulty I simply leave with you at this stage that I have in my mind. My lady and my lord may have a different view of that, and I equally may have a different view by the time we get to the end. But I think it is a real difficulty. We're in a bind because of the way that the appeal has come on without the absence to audit, as it were, what's said about the oral evidence other than thank goodness we've got them, the helpful written submissions that were put in by the local authority. So shall we come back up, given what you've said and given what I know I've got to do over lunchtime, can we come back at 2:05? Thank you.